mention one matter, my lord. Yesterday, my lord, Chief Justice has released the matter for once of determination. Placed before your lordship. Application positive. Yes. Education match.
It has not come. If it comes, it will be listed. Don't worry.
My lord, yesterday there is agencies, my lord.
Sir, this file has not come.
Let it.
You are saying we are not denying, but the file has not come from the Honorable Chief Justice's office. My open instruction is that the moment the file comes, very next day you list the matter. So don't worry. The moment it will come, it will be listed on the very next day. If it comes today, tomorrow, if it comes tomorrow, then on Monday it will be there. No difficulty.
Applications, in connection with first appeal of 2000 applications, my lord.
After 20 years, you thought that one application is to be filed. Very fair. Yeah.
May I have your lordship kind leave to mention one application for inclusion of a lordship list?
What application? Pertaining to what?
Group 2 lordship
Group 2.
admission.
Yeah.
My lord, group 2 hearing.
Hearing.
My lord.
Can you wait for some time, sir? Let us dispose of some of them. We'll definitely include, sir. Don't worry.
Lord, to mention item number 7 of this. But it will not be taken up today, but tomorrow I have some personal.
No, don't worry. We don't know. Our bitter experience is nobody appears in order 41. We can go back.
No,
So wait for a day. Yes, after order 41, we'll go back. Don't worry.
Otherwise, tomorrow I have some personal difficulty.
We always accommodate. Have you ever rejected? Never. We'll definitely. If we cannot take up, just mention the matter at the time of rising. We'll definitely take
Lord, may I have your lordship's kind?
Justice, I have paid the entire amount. Now, my lord, my lord, the sale matter, your lordship pleasure was to let it appear at 2 p.m., my lord, because now, my lord, the property I want to get back.
Wait, this is not a bench, sir. You are mentioning the matter. We will be sitting at 1.
Oh, lordship, I'm sorry.
Lord, may I have your lordship's?
Get to order 41 matter.
May I have your lordship's kind leave, Lord, to seek your lordship's leave to move an extremely urgent appeal at 2 p.m. Lord, I tell you, Lordship, what is the urgency?
Never gave till date.
This demands, Lord, kindly hear me for a second.
You can.
Lord, a medical college,
but,
Lord, the counseling will end tomorrow. Lord, one candidate at the stray vacancy round, he was allotted a seat. He came, she took admission, then she wrote a letter after the date has expired that I cannot continue because I did not get a loan. So the seat is going vacant. We approached the court. The NMC has extended the date of admission till 5th of December. But the state, when Supreme Court in Index Medical College, my lord says that this is against public policy keeping one seat vacant. The single judge on the submission of the state that this will compromise with the merit, Lord, has dismissed the writ petition. Tomorrow is the last day of counseling. We only want that the seat should not go vacant. This should be put into the seat matrix. That's the order that we want.
That can be done on Monday as well. Don't worry.
Tomorrow is the last date of counseling.
Yeah.
May it appear tomorrow at the top, otherwise it will become infructuous.
Let us see, tomorrow it will appear. But this is group 2.
Group 2 appeal.
Yeah.
Tomorrow is the last date of counseling.
Not appeal, application you have filed.
Yes, application and appeal.
Yeah.
But tomorrow is the last date of counseling. We have applied for the certified copy and this is a server copy. Server copy, we have applied for certified copy. 26th is the order, day before yesterday. Server copy is there.
Grant a leave on short notice.
Yes, short notice.
Lord, may I have to mention for inclusion of order 41 matter. Order 41.
Yes.
Mature.
I'm the appellant, madam.
Where is the advocate and record?
My lord will recall that I had mentioned this matter before rising, my lord. Yesterday, my advocate on record can come on Monday. There's a marriage in his family for which
you just said that there is a marriage today, so we kept it tomorrow as per your request.
But
now you are saying let him Monday. Not this week, Corridor.
This matter was heard by the Justice Prasad Malad fourth occasion. The matter now,
Let it go there. Let it go there.
thereafter, their lordship was pleased to direct me to file the grounds which I have formulated by a paper. Matter was directed to appear as forwarders. The ultimately determination change.
Yes, then
Subs-
go there. Let him.
Can take up this matter. Yes.
Why? The matter was substantially heard by
In
another
his
bench.
presence.
Matter was heard.
So why will take up? Let it go there.
Or if your lordship takes up, I don't.
That is appearing on your instance.
Let him go there.
Your lordship can.
You are a landlord or a tenant?
No. Matter merits is in my favor.
No,
I can
no.
settle.
You are a landlord or a tenant?
Tenant. No, I can argue. I don't have any problem. Kindly take some.
Better.
No, Malad, kindly take some.
Is better. Look,
No, Malad,
submitted. It is submitted by the counsel for the appellant that
but kindly take some. Malad. Tenant,
matter was
I can.
heard by earlier coordinate bench on several occasions and was done.
বুঝতে পারে অর্ডার পার্টিশন করবি তুই কপি দিন অর্ডার পার্টিশন বলে এটাকে অর্ডার পার্টিশন লাগে না এখানে একটু লাগে
SMET means order 21 rule 101. Then why SMET?
yes but this is my lord
I think this is from the RERA authority, my lord. So,
So why SMET? Why not FMET?
my lord, it is a statutory appeal,
Sir,
cannot
Guru
be a
Babu.
second miscellaneous.
Statutory appeal is also under order 21
Yes,
rule
but my lord,
101 because of 103.
yes, but the act provides separately, my lord.
That's why
I
I'm saying
don't know why this is
why not FMET?
my first point is my lord kindly don't hear Mr. Rai
No.
don't hear Mr. Rai
Because of the second
because there is no
miscellaneous.
party's date has been announced so
Second
don't give any
miscellaneous
cognizance first point this is the first point
Why SMET?
oh I'm telling you lord see, they started saying in many things but I have stopped myself but there is a dim decree under section 58
I have a point of maintainability, but then let
Just wait.
this act my lord kindly take.
decree.
তারা আমার কোনোদিনই থাকে চাকরি করবো অর্ডার করতে পারবো অ্যাডমিট করবে তার
So it is still to be registered as FMAT. I'm talking about 1980 volume 1 CLJ,
My lord, kindly,
judgment of Justice Chatitos Mukherjee.
kindly see, my lord, chapter 5, rule 17 of the appellate side.
1980 volume 1. CLJ, not CLT was not born.
Not born at that point of time. Likhera goda. Number this initial order, then appeal. Against that order, I am before my
Till FMAT.
nomenclature maybe order 41 has to be.
Till FMAT.
Maybe if even if affidavit order 41 has to be.
Yes. Appellate tribunal এখানে প্রভিশনটা করছে এখন কি বলছে যে
ঠিক আছে nomenclature নিয়ে কি আছে? There has to be admitted order.
কিন্তু ফার্স্ট
হ্যাঁ ঠিক আছে substantial questions means may not be 100. Probably my lord is thinking the substantial question of law.
No. I'm just thinking about order chapter 5 rule 17
Yes,
of the,
that I'm saying,
of the
chapter
appellate side rules.
Yes.
I am thinking in that line. I am not thinking otherwise. I am conscious about the substantial question of law. So that is conspicuously absent here. Section 100 language is not here.
Not there.
Nor like us under the Income Tax Act, there is a provision for an appeal. I think section 263 of the Income Tax Act, where the also says substantial question of law.
Okay,
Okay, sir.
now what to do?
Find out that judgment, Mr. Pordhan, from your, that's, or chapter 5, rule 17, probably 1980 judgment. This is to those Mukherjee.
Then 81, 61,
CLJ.
Appellate side rules, chapter 5, rule
Chapter
17.
5, rule 17.
You just click that, you will get that judgment. Like on it.
এটা একটা টাইপও যদি করে থাকিস তাও একটা কথা ছিল টাইপও কথা নেই Then let us come back without wasting your lordship's time. I don't know whether it may be in my note.
You are a developer or an objector there.
I am a developer. What happened, my lord? By virtue of a power of attorney, I was constructing. It was not known to me that one of the power of attorney grantor died. His son, who is the plaintiff, is the joint power of attorney grantor. Now, my lord, when my construction is almost verge of completion, an application was filed before the authority. The authority in the first blast says your application is not in form. Return it. Then order has been passed behind our back. That appeal against appeal court said, I will hear the main matter. I have substantial construction has been made, everything that has not been taken care of. This is a sum and substance.
So there is no fetter. Only thing is they wanted to hear. Let them hear. They may ultimately dismiss, not inform.
What about me?
What about, there is nothing.
2008-11 SEC is sharing on the face.
That is another judgment if there is an injunction against
That
you.
has been granted.
Oh, that is what you just say. The appellate court says.
Otherwise, I will
yes,
not come.
We will hear out the matter.
Otherwise, I will not
We'll
come
hear
here.
out the matter. So I just say.
Otherwise, I will not come here.
The matter.
They
You did not say there is an injunction.
My fault.
How do I know? Then you are referring 2008, volume 11, SEC, page 1, paragraph 27 or 24 of the said judgment, right-hand side page at the bottom.
And thereafter also these
2009 judgment of Justice Chatterjee.
Your Lordship's court judgment also there.
Justice Bhattacharya.
2009, I appeared.
Yes. This is the sum and substance. My lord, if your lordships are satisfied with the nomenclature and admission, then otherwise let us come back. পেয়েছিস? হ্যাঁ ঠিক আছে তো সেটা সেটা তো বলেছি এভরিডে এভরিথিং ইজ দেয়ার উই ক্যানট কনস্ট্রাক্ট
An ex parte injunction is granted or
ex parte injunction granted and in an application which was not allowed because of reverse of form. Urgency cropped up, nobody is no fresh application. Injunction granted. Oh, তুমি তো আছো তুমি করো maiden appearance মানে it is maiden appearance maybe.
what made an appearance?
Yes, senior advocate has made an appearance.
Where?
দেখাও না জোসেফ দেখতে পাচ্ছে না but don't see because don't give any cognizance because no party has been thrown up till now. That side also.
No, Mr. Ghosh, unless it is notified.
I told everybody, some person said that court has said why you have not worried. But unless we are learned, I was not wearing. The court said
Unless
you
notified.
cannot unless bar council registration number is given.
On the official notification.
Bar council enrollment is required.
Yesterday, I was wearing the ordinary company. Mr. Mitra, Jayanta Mitra told me that if you cannot wear it, we shall raise subscription and purchase it. Where you have not owed it. But that's why yesterday, at the time of not returning home, I purchased it from Gajkumar Brothers, and today I have.
আছে না সব ফাঁকা হয়ে গেছে শুনলাম তো
That is the reason. Otherwise, Lord, I thought that it would be.
Requires a notification.
আমাকে
মানে না কিছু আমি কি বলবো আমি বলছি চিঠি কই চিঠি থাকবে না
Your name, Mr. Basu, was notified. That was the notification, budget notification.
my name was not there not has come from the bar council. I was not wearing. The honorable division bench, I can remember Justice Punab Chattopadhyay said, why you are not wearing? I no notification from the bar council. Then he said, wait, I am trying to get it. Then in the evening he got it and thereafter the following day. I don't somebody told take it to your lordship's name also.
Rather, I have
I
been
don't
compelled.
think.
Rather, I have been compelled. I thought that after notification I had wait. But yesterday,
Have you got that judgment?
It's not there in SEC online, but it's 1980 volume 2 CLJ 161.
Yes, that is what is I'm saying. Volume 1, I said, volume 2.
Surajwal Jain versus Probate.
Correct.
1980 volume
It says that whatever does not come, it says whatever does not come under chapter 5, rule 17, it has to be registered as FMET.
Well, it can be converted. SMAT, both are order 41 has to be admitted.
I think Justice Chittosom's Mukherjee said.
Let us look and come back.
No, you kindly, because there are some judgments saying to the contrary. I won't cite them today because of what not.
You will not do the matter behind my back.
No appeal lies, only revision lies. May I look into?
No. Appeal is a creature of a statute. If the statute provides for an appeal, then in that event, it has to be. Section 58 is very clear. It says any person aggrieved by any decision or order of the appellate tribunal, he can prefer an appeal to the High Court. So once the right of appeal is conferred under the Laika Income Tax Act from the Income Tax ITAT, they call it a Income Tax Appellate Tribunal. Appeal lies to our High Court. What are you talking? Section 58, very clear. No revision lies. Revision lies when under the Code of Civil Procedure. Because that is an appeal under section 104.
This is decided in the statute
Just
itself.
wait. Let me tell you, Mr. Mitro, that was an appeal. I tell you, in the civil judge junior division, an injunction is passed. It is an appellable under Order 43, Rule 1R before the district judge. That is under Section 104 of the Code of Civil Procedure. That appeal lies. And the moment that order is passed, then there is the Section 104, 2 or 3 says no further appeal lies. Then the question arose that whether a second miscellaneous appeal will lie. Court says no. Once there is a bar of further appeal, then it's a revision which would come. But it is a statute, special statute, which says that the appeal would lie from a tribunal.
Well, I will cite them, but then our High Court also stood there, Lordship will then.
What?
Our High Court judgment is also there on
What? On RERA.
Section 58.
On RERA. I would venture to differ.
No, on HIRA, but then same provision.
I would venture to differ.
Of course.
If there was no right of appeal, nobody can assume such right. If there is a right of appeal conferred, then that right.
If he has some citations, let it be shared with us. Let us come back.
What are you talking?
No,
No. Or it can't be. It cannot be. Those are all under Section 104 of the CPC. All under
no
section.
further appeal lies, then
No further
like
appeal lies.
Ruby General and all those judges.
Whatever, then it says revision is the proper mode, because appeal is a creature of a statute. Unless the statute provides for an appeal.
Maybe I will not. Since
I
Lordship.
don't agree. This Section 58 is very clear. It says appeal lies to the High Court. From an appellate tribunal's order. No. Unnecessarily do not put a spanner.
No, I was supposed to I would like the
No,
law to be laid down, clarified. Because if our High Court judge.
Section is very clear.
If our High
What are you
Court.
talking about? We are laying down here and now. We are laying down here and now. What are you talking? Can't be. Impossible. I believe nobody would argue this. Or ever argue this. After looking at Section 58. It says appellate tribunal. It does not talk about a tribunal.
Sure.
So, you have done the income tax appeals, I believe.
Long
From
back.
an ITAT, that's an appellate tribunal. From a CIT, it goes to ITAT ultimately. CIT appeals, then it goes to appellate tribunal, and from appellate tribunal, the appeal lies to the High Court. Substantial question of law. Section itself says.
It is in Companies Act, if you're 10F, there would not be
different.
37 Arbitration Act, there cannot.
That's the conferment of the power of appeal under the statute. Can't be.
I don't want to cite something which. Lordship.
So, unacceptable and unbelievable.
Lordship, kindly.
Should I start?
What?
In the merit, or can you give me leave to correct it?
Affirmative.
Affirmative, order 41, by any means, order 41 has to be there. Can you give my learned advocate record to correct it with the leave of your lordships?
How can he correct it? There will be a separate categorizing,
Right.
separate number to be given by the central filings.
After that, it will be sent back. After your lordship admittedly sent back for correction.
Order would be under SMAT.
Special category of.
That's true, but what I am submitting,
He
technically
was-
go back after your lordships admits it, is to go back to the for correction.
How the appeal was registered there before the appellate tribunal.
May I just a minute?
Miscellaneous appeal.
That is WBERAT stroke appeal. Appeal. By any means, it was an appeal. And now we are against the appellate tribunal.
কোন সেকশন হয়
আমি তো সেটাই ভাবছি এসএমএটি হওয়া
আমি জশের বলছি না আমি
this may be second appeal, my lord. If there is any doubt of my lord, kindly clear it up. So for we are concerned, rule has to be in order 41. To correction by. Mukosto, just say Mukosto, no? Chapter 5, Rule 70.
I'm searching for a person who appears in the income tax matters.
Oh, তাহলে গুট্টুকে ফোন করবো? Should I call Mr. Khaitan?
How it is categorized?
I can call him.
Because Allahabad High Court in this context has said office is directed to create a special category of appeals which are preferred under 58
It has not been created, but it is.
and not to register as second appeal but as RERA appeals. That's what the Allahabad High Court. Calcutta High Court.
CIS. That is for the purpose of CIS.
So Calcutta High Court has said revision which no, sure.
There was no appeal.
The what?
That
The
is
what
different.
appeal? Must be under section 104 appeal. Must be under section 104 appeal. Look at it, the fact from which order that was challenged. Which order?
West Bengal Housing Industry Appellate Tribunal.
West Bengal Housing Industry Appellate Tribunal.
It has gone because there was
Yes,
no
but the
provision
section is parameter. Section 58 is there.
like provision under like 58. No, it was not.
No, 58 was there.
And this is repealed, declared as ultra virus by the
That we know. That we know.
HERA or HERA, I do not know.
Hera, H-E-R-A.
And RERA is there. But 58 এখানেও similar.
Someone, Mr. Khaitan, he is coming.
Phone Mr. Khaitan done. Mr. JD.
Then Rajasthan High Court has said on analysis and examination of relevant provisions of RERA, this court is of the opinion that against the decision or order passed by the appellate tribunal under RERA Act, appeal filed under 58 can be entertained only on the grounds specified under 100, section 100 of the
That is
That is the different. That
substantial
is
question of law.
maintainable. That shows appeal. Then if that is accepted, then you'll have to keep your mouth.
That.
Our division bench judgment says that in a second appeal, the respondent has no right of audience until the admission is done.
And I was rebuked
Then
by
you'll have
friend.
to. We will not hear you.
No, only if it is second appeal, if they file a second appeal.
You are citing.
No, but then if they file, but
I was saying so.
they have not filed a second appeal. They have not.
It should be treated as.
So once they do it, well, once they do it, then only. Once they do it.
Then all of you cannot appear and cannot argue unless we.
Appear and RP was no argument.
But only if it is second appeal, they file.
Judgment, our Justice Ganguly's judgment of a division bench.
I was the culprit there. I and Mr. Bimal Chatterjee. Justice Ashok Ganguly and Justice Rishikesh Banerjee.
Right of audience is not there under order 41 rule 11 in that second appeal. Right of audience. Unless the court admits and frames substantial question of law, that is what the judge.
It has to be a second appeal first.
What is the name of that appellate court? First name?
That matter. That I have, I appear there.
No. The appellate.
Kaur.
Kaur, and the first name I am just. That's the surname. I'm just forgetting the first name.
Not Kullam
That is Justice Ganguly. That is one of Bengali people, not Kaur.
Punjabi lady.
I know the person. He is a palmist.
My memory.
He is a. I know that.
Memory have not betrayed.
I know that.
Now.
I find.
As of now,
I don't take it otherwise. My lord and my senior. Memory is.
Future, my.
No.
Future, I do not know.
The gentleman was the Bengali. He was a palmist. That much I can remember. আমার হাত থেকে পড়েছিল কিছু হবে না।
Anyhow, that now you have. I really do not want to go into this aspect. Now it will go on in.
No, I will
unless
supply.
I find out.
In the evening, I will supply.
No.
It is in my note.
It will continue unless I find out.
What unnecessary thing don't have. Cracks your brain.
What is this called? Find out. AUR. Surname I know.
Right.
Appellant. I think
I
the
was
name
with Mr.
starts with the letter S. I believe so.
I was with Mr. Bimal Chatterjee, and other side Mr. Dasgupta was there. Code number 12. That's much I can remember. 12 নম্বরে ছিল, আমি ছিলাম থেকে বিমল দা আর সুদীশ দা আর 12 নম্বর।
Have you got?
That judgment.
ওরা পর্যন্ত
অসংখ্য ঋষিকেশ ব্যানার্জি হ্যাঁ দাও সুরেন্দ্র কর পটা পটা পটা
I know that. দেখি আমাকে দেখি একবার কোনটা এটা কিনা।
Does not have not betrayed as of now. Surinder.
Oh, I was for Jyoti Ranjan Banerjee. This much.
Whatever, sir. I know the name of the appellant.
Yes, yes. I was for Jyoti Ranjan.
It says you have no right of audience unless the appeal is admitted and substitution of voice. I said the name starts with the letter S. But I was not recollecting Surinder.
ওই জন্য পাঞ্জাবি বলছিল।
Anyhow, what to do?
Let me proceed.
Admit?
Yes, admission is
only on substantial questions of law. Only on
If
substance.
it is SMAT.
Otherwise, it is not maintainable. If it should be second appeal.
FMAT.
Classification is the internal mechanism of the court.
SMAT. 58 provides it has to be
I also, we have a talk. Initially, my impression was this. Then we have a discussion and then find it should be SMAT.
But then here also it says only on one of the grounds under section 100.
Where?
Section 58 says. Any person agreed by the decision or order of the appellate tribunal.
Oh, section 100. So you have no right of it.
On the grounds of 100, not section 100. The grounds of 100.
Then you have
Section 100, my lord.
Let us see whether.
Also, my lord can remember 2003 Supreme Court. It says whether this suit was filed correctly or not. It is also a ground of substantial question.
But in their appeal, they are framed any questions of law. In their
The ground of appeal memorandum.
Normally we say that these are questions of law that
What
arise.
is it?
No. No, you are not correct.
Third, in the last page, I think you have included or invaded the zone, which is very risky. The last certificate is appended. It says, I certify that the above are, in my opinion, good grounds of appeal. I undertake to rely on the same at the
Entire
time,
team is from this side, so we have taken care.
which is a requirement under the appellate side rules. You'll have to give a certificate.
Okay.
This is the memorandum.
Page 11, certificate there. What is this?
Now, my lord,
2008-11.
that will come later. Let me give you the facts. Now, kindly come to page 57, the complaint. Briefটা কোথায়?
Sorry, a little digression was done. I think SMAT should be the correct name.
Okay, I'm not venturing to say anything here. I'm not even, because I'll be trapped if I go into this issue by your lordship.
Can do. But kindly take the can, 5. SMAT can, 5.
This is
5.
what?
SMAT 5 and can 1. দুটো আছে না? তারপরে গোপালদাও বলে যায় তাহলে stamp report
Where is the certified copy?
There is no report of the stamp reporters regarding this.
Yes, where is the certified copy? Oh, certified to be a true copy.
এটা দিয়েছে ফাইল করে may I proceed, my lord? My lord, did not be travel with the entirety. 57 kindly come to 59.
No, the court has said we are not trying to pass any interim order of stay at this stage. What is the order?
Stay
of
means
judge?
the stay of the injunction.
Where is the injunction?
My lord, before that,
Injunction
may
is
I
granted
proceed?
By the RERA.
Yes.
Say that, you say the RERA
I
says
said
it's
that.
not informed.
Yes, I'm saying that, sir. Kindly give me minutes time. Kindly come to page 57. This is the application, the genesis of this proceeding.
No, let me see the order.
Which order, my lord?
RERA.
No, before that, kindly see the question.
No.
Before that, kindly see. This application was not entertained initially. This application was not entertained. বলতো দেখছি কি দেখছি সেটা আমি কিছু বলার দরকার নেই এটা খুব 26 from this similar so is this 27 you must get this just the color.
What has happened on 26 September? What happened?
Which order is my lord reading?
For the appellate authority.
সেদিন কি হয়েছে তারপরের দিন কিছু হয়েছে ও after filing is it adjourned. May I proceed in my way, my lord? Kindly come to page 57. That's the application filed by the plaintiff or the applicant. Substance of the allegation is at page 59. Kindly see the date when it was filed. Right? Yes.
Seven, then
Well, kindly come to 59. The substance. I am not. Kindly see the date when it was filed, and then kindly come to the substance.
what is the date? Is the letter is dated 18/7.
Yes. Now kindly come to 59. What is their allegation?
No, allegation starts from.
But those are not their allegations.
Page,
According to them, the fraudulent transaction, it is at page 59. That is the main allegation.
because it says that the partnership firm, on the basis of the power attorney, the deed of conveyance is executed in favor of two persons, and the two persons then entered into a development agreement with the third person, and then the construction is going on. So they are really impinging upon the sale that was affected because the partnership firm gets dissolved immediately upon the death of one of the partners.
When?
That is
It has
what
to be communicated. There is a law. Let us come to the facts first. Kindly come to the 59. What is the fraudulent transaction here?
Yes, that is what.
My lord
it's
has
saying.
seen that. Now kindly come. My lord has seen that the date of the application. Now kindly come to 62. The competent authority is passing an order on the application. I repeat, on the application, order is passed. With reference to the letter as stated above, this is to inform him that to get redressal from WBRE authority, he may apply through the such and such in prescribed form and depositing requisite fees. Application was not entertained. It was communicated to me. Kindly come to the bottom. Copy forwarded to me.
P62.
My lord has seen that. Kindly see the date, 29th August 2024.
62 কোথায়? জানি 62 আমাকে।
On that date, the competent authority entertained the application, said it is not informed. Thereafter, no communication. All of a sudden, my lord, the same application was taken up and order has been passed. Kindly come to the impugned order now. The before the authority is 63. 10th September 2024. Same application. There is no further application on that date.
Have they uploaded it through a website?
Which one, my lord?
The letter at page 62 says that you may apply through a RERA website.
It was addressed to them. It was addressed to them, addressed to me also.
Subsequently given, anything was.
No, I will show to your lordship, after the appeal was disposed of, a fresh application has been filed now before the court below or the authority below.
Appeal is disposed of. Where is the appeal disposed of?
When the appeal was pending, I have not disposed. Appeal was pending. On that date, my lord, a fresh application in terms of the page 62.
But that's the whole thing is that you are jumbling up the facts. So I take it, what I gather is that on a day when they filed this letter, the RERA says that it is not informed. You have to upload this particular whatever in a prescribed form, which is provided.
Yes.
Then you say that without filing it, the RERA entertained that application, which is not in format, and then passed an interim order of injunction.
My lord, correct.
Against that, you preferred an appeal. The appellate court admitted the appeal, but did not.
No order passed. This point has not been taken.
Did not stay. Then you say that on the day when the appellate court admitted the appeal, they uploaded the application.
That is on 17th September.
In an income tax appeal against ITAT tribunal, how it is registered? FMAT or
ITAT, income tax appeal tenders. And then after admission, it is
ITAT?
ITAT, then the number.
Bracket T.
No, but it's ITAT as a whole without brackets.
Then before the ITAT, how it is registered?
Before the tribunal, it is IT.
ITA. And here is a ITAT.
ITAT initially, then after admission, it is ITA.
Both.
Both are.
Both tribunal and here also.
Yes. But no, that does not create any confusion as such.
No, there is a confusion because now everything is on the website. If somebody just gives a number, then he will get the same matter before the tribunal, and also tribunal has also uploaded. So categorization has to be different.
Yes, perhaps in that sense, yes, we as such the tax practitioners don't get puzzled, but yes, if anyone else looks at it, then
now the difficulty is that we have introduced this, everything is to be uploaded. That is under the CIS system.
260 the order.
Where with a one click of button, you can have all the details of the litigations anywhere. That is judiciary, we can say. That is what I was just, if in future they integrate the tribunal also there, CIS, then there will be a confusion.
Of course, then definitely not there should be a different numbering system.
I think the SMAT should be and that is in the appellate side or in the original side?
Original side.
Oh, and appeal lies in the original side.
The rules have been framed, I guess. The High Court rules are on the original side, and that is how it is. I do not know the origin of it, but that's how I have seen it for the last 40+ years.
The original side rules contains that appeal from a tribunal would lie. How? It should lie in the appellate side.
But it is in the High Court rules are in the original side. The provision for the appeal is in the statute, of course, not in the income tax act.
How? You belong. He belongs. How? A tribunal order in the original side.
The commissioners are all perhaps not in the original jurisdiction.
No. It can't be. It's an appeal. And the appeal in the original side is only under letter of president, clause 15.
No, the earlier it was used to be the advisory jurisdiction where the case was.
But now section 200 and what is that section? Appellate section
268.
268. I was to 263. I was closer.
But that
is based on a substantial question of law.
But from 1998 that has come. From October 98.
So that is to be framed because unless the substantial question of law is framed, it is being framed.
Yes, but the suggestion in the memorandum of appeal, and then the court takes it up for admission. At the admission stage, not the questions.
Second appeal, we also do the same thing. They give a grounds in the memorandum and saying that this is what the.
No, questions of law are suggested in the memorandum.
Questions are also
Questions of law are suggested in the memorandum. That's whatever little like that. So that's why I said, well, there are no questions of law suggested in the memorandum.
It does not provide for.
But in fact, not when this.
A language section 100 is the court is to frame the substantial question.
It is a court who has to frame. It's not that they have to suggest.
But some amendments were also made by our court regarding the procedure for the 260 appeal. So it is in that sense.
Fixed that. Actually, I have a my lordship's. I have.
Look at rule 6 of the appellate sections. Right hand side, top, rule 6. Form of certificate is also provided in the rules itself. So need not have to write something more beyond that.
But for the 260 appeals, there are rules of our court. Just see if they're here.
Anyhow, I was just thinking, anyhow, then SMAT, I think that would be
Sure, I have a.
distinguishing this, and I will take care of that also. Can't be.
Kindly have a look at the rules which are already there, so that
Just take it. That was all the IT department and also original side department. Just take care.
Yeah, I have a. Well, I had a 11:30 fixed it started, but it's in a different place.
What?
I fixed it. I had a. No, I have a continuing part.
Yeah. No, just. And what is the stage? We are admitting it, but the appellate tribunal is there. Can we now I'm telling you, the difficulty is, can we direct or request the appellate tribunal to dispose of the matter within 15 days? Take all the plea there.
Kindly see kindly see.
No, the difficulty, I understand.
Before my lords, I cannot cite any judgment, my lord. Morgan Stanley, Chadda, no, I need not. But kindly see the order. And kindly see when the matter was taken up for hearing, the application was not informed. Same application not rectified, passed. Subsequently, application has been filed on 17th September after the order is passed. And can you see the order once? Have a glance. Once the order.
I've seen.
Any semblance of reason for passing any ex parte order?
This is the next. Next. Which is. ওই 2008 থেকে 11টা শেয়ার করে ভিডিও করতে সেটা করে কিসে
Look at the memo. What order you have?
তোমারটা খোলো 11 সেপ্টেম্বর খোলো
So how do I know? No, no, your memo, we will concern with
No,
our
no, no,
copy.
my last copy. This is our fault then. Preamble আছে?
Concerned with our copy.
Yes, certainly. Preamble আছে তো? Memo preamble
Take a preamble. কে দাও না ওরা কি করতে পারে?
কবে আছে 11 সেপ্টেম্বর
No, no, I am not. Please kindly consider, sir. These are all independent order. Whether you have filed an appeal before the appellate tribunal against an order of 11 September.
Yes,
Where
yes.
is that? Which one is this? 27.
That is, my number is 27 of 2024.
Oh, it is against 11 September. Anyhow, yes. It are.
Appeals filed.
It are. Yes.
I have got another copy of the 11th September. And a copy.
This is absolutely a new act. I'm taking a long time.
I am totally at a loss with this.
Because I
On
have
top
never-
of that, Lordship
I have
adds the.
never come across and reading those provisions. Because it came after my departure from there.
See, may I take my lord? Can I leave my lord? My lord, if required. অনেক রোজগার করেছি তখন অ্যাপার্টমেন্ট ওনারশিপ অ্যাক্ট ছিল প্রমোটার্স অ্যাক্ট ছিল but এখানে রোজগার কম হয়ে গেছে of the appellate authority here the matters are very few because of the two
It has just been constituted.
yeah also bala there's one authority then appellate authority only on questions of law so very few matters come
চালিয়ে দিব না ওখানে আপনি চালিয়ে
কৃষ্ণা সর্বময় আগে থেকে বাবা থেকে করতে ইচ্ছা এটা থেকে করা বাজে আমার করা না
প্রথমটা
আমার
এটা 99 that
File the certified copy of the trial court's order, my lord.
Both the matters?
Yes.
In both the matters?
No,
In both
no, একটাই, both this is
or in one? 4 and 5. Certified copy in both.
আমি তো বলছি
I
একটা।
know it.
One.
The difficulty, that's why I say I don't believe.
One.
I don't believe.
Because I find 2 copies has been handed over, so it is in one.
I understood because I noticed one was a photocopy in which you filed order dated 11 September or what? Both dates, certified copies are there. One is photocopy, 8 September, one certified copy, one photocopy. 11 September, one certified copy, one photocopy. What you have filed?
তারপরে তো দিয়েছে।
I filed the photocopy. Hereafter, which order of photocopy of which order? Appellate court or the order or the trial or the.
Appeal court certificate copy is there.
That is the whole problem nowadays, I'm telling. No.
Record.
সোমবার 2-12 64
Sorry, I kept you waiting. This was.
64.
Memorandum of opinion. Does not contain an affidavit. Memorandum of opinion does not contain an affidavit.
Lord, I am the plaintiff in a suit for recovery of possession.
Lost.
In a suit for recovery of yes.
I'm just asking.
Yes.
It's a surprise.
Plaintiff
On what
in a
ground?
suit. Plaintiff in a suit for eviction, recovery of possession from a lessee after expiry of lease by efflux of time.
How the both the courts or
Both the courts, everything held in my favor. One thing went against me. The suit was filed by the constituted attorney of the plaintiff. The power of attorney was not filed.
কি অবস্থা দেখো
Kindly seize my lords.
No. Suit was filed by the lesser through constituted
Yes.
attorney or
By the lesser,
constituted
no,
attorney
by the lesser,
as
by the lesser,
through
through the constituted attorney, the power of attorney was not filed.
who came and deposed? Lesser or the
Power of attorney holder, being the husband.
one is an alter ego of another.
And most importantly, this point not taken in written statement, not taken issue.
The appeal shall be heard on the following substantial question.
Which was
Deed for lease was
executed.
there.
That agreement expired long ago.
So
Deed for
That agreement expired long
then
ago.
argue on merit. When, Mr. Bhattacharya, your convenience.
Then your lordship
Next week,
and
next week, any day.
next week
Your
the
convenience.
Supreme Court circle. Two weeks here. 2 weeks.
You make it one day in the next week, any day. That is a request from the bench.
Oh, no, any day.
Thursday?
No.
Next
Thursday. Next Thursday.
Since the respondent has entered the Yes, call the next.
65. Sixty-five.
My lord, in item number 65, my lord, Miss Antara is appearing for the appellant, my lord. My lord, someone from her family has passed away, my lord. I have instruction to seek a week time, and she needs to file section 5, my lord.
Let it go out of this. Because section 5. we
My
can't
lord, the
entertain.
section 5 is drafted, my lord. It needs.
Madam, this is the second appeal.
My lord.
Division bench cannot entertain section 5. It is to be entertained by a single bench. So it's better to let this matter go out of this. You file section 5, mention before the single bench. Let it be disposed of. Then you come under order 41. Now,
There was defect, my lord. So far, deposit court fuel. I have deposited. I have deposited.
Deputy Court, what is the matter?
The matter, my lord, I am the defendant in the suit. The suit was, my lord, for eviction of licensee.
Licensing.
Judgment of affirmation.
What was your defense?
My defense that plaintiff appellant, my lord,
Yes.
during sending second notice of eviction.
Matter number 67.
Who are you, sir?
I am the
Plaintiff or defendant?
defendant, my lord. In eviction suit, my lord, OC suit,
Judgment of affirmance or
judgment of affirmance, my lord.
performance? What is the defect?
Lost in, my lord,
What is the defect?
my lord, there is, my lord, that is plaintiff filed the OC suit before the court
I
said,
am talking about what is the defect?
my lord, the suit property is a vested property, my lord. And that aspect has not been considered, my lord.
Defect.
My lord,
Defect.
my lord, suit
I think
property,
I am not audible to you.
my lord.
Should I raise my voice?
No, my lord, I tender.
I am asking you what a defect.
The suit property is the vested property, my lord. That aspect has
The
not,
defect of the
that,
appeal.
that aspect has not been
This is
considered,
the
my lord.
defect in the appeal.
My lord, in the appeal, my lord, there is a issue, my lord. Issue number 3, my lord. Taken. Oh, defect, my lord. Oh. I could not follow, my lord.
Have you seen the list?
My lord. Tender apology, my lord. Let me see that. I will defect, my lord. Clear the defect, my lord.
Yes, certified copy of the trial court judgment you have filed.
My lord, I filed
That is
subsequent.
the defect. Take your seats. Wasted property. Matter 6. Eviction suit. Wasted property. Plea of vesting. Nay,
My lord.
no.
Plaintiff filed the suit, my lord, on the ground that he did not want to
Bengal
continue.
Constituency Act does not extend to the area.
My lord,
West Bengal Constituency Act is not extended to the area.
my lord, it is a case under section 106 of the Transfer Property Act, my lord. Notice has been served, my lord. And on the ground, he has served notice,
In one question, it is not extended to the,
my lord.
yes. Yes.
Notice has been served, my lord, on the ground under section 106 of the Transfer Property Act, my lord. On the ground, my lord, the plaintiff did not want me to continue in the suit property, my lord. Only on that ground, my lord, he has filed the suit, my lord, and he has claimed the title over the suit property, my lord. But the suit property on the ground, my lord, that the property originally belonged to his father, my lord. That by virtue of the deed, my lord, that deed has not been produced, my lord. And thereafter, my lord, they have claimed that he has got the property by virtue of the partition deed, my lord. That deed also not been executed properly, my lord. As per the exhibit 4, my lord, that has not been properly executed till date, my lord. And that said exhibit has been executed, marked exhibited, my lord. Annexure 4 series, my lord. The deed, partition deed, my lord. As per the marked exhibit, my lord. That deed has not been properly executed till date, my lord.
Not executed properly means?
My lord, that has not, as per the, my lord.
Properly proved. What do you want?
No, my lord, that
executed is one thing and
not registered, my lord. Not registered, my lord. As per the
can there not be an oral partition?
My lord, that property, my lord, as per CS case record, my lord, the property is vested, my lord. Subsequently, it has been recorded in the name of the father of the plaintiff, my lord. But it has not been explained how the property is being.
Do you want to say
Come,
that the form of retention they have filed or
no
not?
proceeding has been. There is no. This is the heart, my lord.
Whatever the retention is permissible.
As per CS record of rights, my lord,
after the State Acquisition Act came, there is a provision under section 5A and 6. Option to retain is always there. You don't know, they may have exercised the option of retention.
It is not the case of retention, my lord. It is they claim they have purchased the property, my lord.
What purchase? They say that their father was there and the father has his name is recorded in the record of rights.
RS record of right, my lord.
All through LR also.
No, my lord. Kindly come to my lord. LR also, my lord. LR, see, RS and LR record, but when the record, the property is vested to the state as a CS record without any proceeding, my lord.
During the revised settlement, CS was earlier. It is after the State Acquisition Act, the revised settlement was done. RS, if the RS indicated their name, then what?
My lord, without any proceeding, my lord, how the property can be, my lord? I asking myself, my lord.
Why it is required to be proved? Who are you?
My lord, they have.
First, tell me who are you?
My lord,
are you above the whole world?
My lord, plaintiff claim that I am the tenant. My lord, actual fact that, my lord, I am not tenant under the plaintiff, my lord.
Why you admitted in your evidence that yes, there is a landlord and tenant relationship?
My lord,
I paid rent to the landlord.
What happened, my lord? In my written statement, I have clearly stated, my lord.
Why you said in the deposition that yes, I paid rent?
On compelling circumstances, my lord.
Compelling circumstances.
My lord. I have a shop room, my lord. He has obstructed me, and I have simultaneously paid rent to the Jomindar and also the plaintiff, my lord.
That's all?
My lord.
Anything more? No. Yes, sir. Both the courts have concurrently held that the notice under section 106 of the Transfer of Property Act is duly served and cannot be said to be invalid and or infirm. Next one. Admittedly, the suit premise Call the next.
Page.
Plaintiff appellant, Lord. Put plaintiff appellant is before your lordship, suit for specific performance of an agreement. The trial court decreed the suit. The appeal court, Lord, concur with all the findings of the learned trial court, but on the simply question that the suit property is not properly described and it cannot be executed, he has allowed the appeal. So kindly see. So the learned appellate court has ignored the admission made by the respondent, which has been recorded by the learned trial court, that he said that it can be executed, and he was.
Where is that?
Lord, your lordship, kindly come to page 20, last paragraph of the trial court. Consider the
No, it says that if it is decreed, it cannot be executed due to vagueness of this schedule.
no, thereafter will kindly proceed. PW1 in his cross-examination has deposed that and what his purchase deed from whom he has purchased, there is specific direction, demarcation, and boundary. Even if, Lord, it is a joint property, Lord, I can purchase the share. Thereafter, I will take steps for partition. So for that, on that ground, Lord, my suit.
Show us the appellate court.
Lord, kindly come to the page. This is not appellate court. Last page at page 13.
Page
13. The beginning, a specific performance degree.
No, that he talks about the vagueness and uncertainty in the terms of an agreement. But it does not talk about what is that uncertainty or vagueness.
Nothing, Lord, there is no litigation. There was not.
No, what is that? Why it says so? Show us that it says that it is a joint property. It is not a exclusive property of your vendor.
Yes.
Show us that.
Lord, kindly see the agreement itself. I have annexed the agreement.
That is wrong.
Yes.
That page. The appeal shall be heard on
But I've been told that appeal court also, my lord, there was an interim.
Not told.
Lord, your lordship, my lord. Kindly, my lord, I have ascertained. That's why I'm telling you. Otherwise, it's not with me. Otherwise, my lord, he will do anything.
Rob, you are now a senior advocate. You should.
Lord, yes. Lord, kindly, I think, Lord, it is not with me.
This is
My Lordships, I appear on behalf of the appellants. I'm being led by Mr. Rashad Madora. He's before his legs on on another bench. Lordships may kindly not take this up today, or else.
I'll just indicate something, my lord. I appear for
My
the
Lordships may kindly grant a pass over, short pass over in that.
Clause C.
My Lordships may kindly grant a pass over in that occasion.
Clause C.
I have perused clause C, my Lordships.
So that's not a ground for.
I understand.
So what can be done?
I understand, my Lordships. May kindly
We
grant
are
a pass
bound
over.
by the law. We can't go and defy the
Could
law.
I provide him a ground for adjournment, my lord?
These are the grounds.
I know.
Look at it.
I
Order
know.
17,
I know.
Rule 2 says
Rule 2.
engagement of a pleader or
It's
a
not a.
counsel
It's
in
not a.
the court cannot be a ground
No,
for.
I'll give him a better ground. No, I'll just indicate. My lord, this is a suit for specific performance. I'm the plaintiff respondent in the appeal, my lord. My lord, an ad interim order has been passed from which the appeal is preferred. My lord, he's the purchaser of a flat for value. A substantial amount, my lord, is outside.
Without notice.
Yes, yes, without notice. My lord,
That is the equitable defense he has.
but that's
A bona fide purchaser for value without notice.
No, but not having.
As the equitable defense.
Correct, you're right.
So,
But my lord, here he hasn't paid the entire amount. I'll just indicate 1.5 crores, slightly more than that, outstanding. My lord, the only order is, which has been passed, is that without paying that amount, he can't get possession. That's all. So, my lord, he's really not suffering anything. But the issue which has arisen is multiple extensions have been granted, and I believe your lordship is part of that bench. Now, when that order is made, post that order, my lord, extensions, they filed 2 memos of appeal separately. Now, my lord, there's another extension. I believe, my lord, they'll have to file another memo of appeal. That's why I said I can give him a ground for an adjournment.
he will face the but we now we point a
Lordship is presiding over that bench.
Kochi.
Hiranmay Bhattacharya had referred to the larger bench.
He's a part of that.
Right, I know.
With Justice Sarkar. You are appearing in that matter. You are not. Who is appearing before the special bench? The bar karo jadi dokar hai. That's the point, and the point is refer to a larger bench, special bench.
Sorry? Say sorry. Please for the appeal court.
If he has taken a point, then difficult. Why don't you take out immediately?
Yes,
we are adjourning for not this week. Yes.
Grateful, Milan.
Not this
Much obliged.
Great.
Suit for eviction. I'm the defendant. Number judgment of affirmation. The only thing, though there are certain ground, but before going into the merit of the instant order 41, my client is ready to take away the shop room, but she only needs a year time because it's a grocery shop. He needs some time. If you also can give me a year time, we'll bracket that.
So the inhabitants of the locality will be deprived. They will be without any food.
Suit was filed on the ground of
whether the execution case is pending.
Yes.
Without admitting the appeal under order 41 to 11. We feel that the presence of the respondent is necessary as the appellant submitted to the court that
For the plaintiff respondent appellant.
Judgment of affirmance.
Eviction. Plaintiff respondent appellant.
You
Decree
won
for
in the trial court and lost in
yes,
the appellate
yes,
court.
my lord.
What is the nature of the suit?
Eviction of a licensee filed by the father-in-law against the daughter-in-law. The defense was
Father-in-law against the
daughter-in-law.
Why
The
the suit is dismissed? Why you do not want daughter-in-law to be there?
there was a long-standing dispute, that cannot be.
With whom? With you
But
or your son?
the daughter-in-law has expired. Now the son has substituted in her place. Under section 62, the Easement Act defense has been given, completely going beyond the admission made by the defendant in the suit. The defendant's defense was that he is not a
Why
licensed.
you do not want a son to be with you?
There was a criminal proceeding, counter criminal proceeding.
Why? What is
There was a long
you have other sons.
I need to take instruction. I do not know. There is a long-standing dispute of 16, 17 years.
About it. Every dispute is a long-standing or a short.
There was a criminal case, counter criminal case.
Now the relationship of a father and a son.
But the son is married, my lord, and there was a criminal.
Now he's a widower.
No,
Because
no,
the daughter-in-law, you said that.
My daughter-in-law means the suit has been filed with the father-in-law against the daughter-in-law. The daughter-in-law has expired. Yes, son is widower. So son is widower.
So what are you talking about?
The thing is this: there was a.
Why you do not want your son to be there?
What I have instructed, there was a criminal case, counter criminal
case. Maybe at the behest of the daughter-in-law, not at the behest of the son.
Then I have to take.
Now the daughter-in-law is no longer there in the world. That is a change circumstance.
A change circumstance. Even then, my lord, the keenly contested suit, my lord, and my lord, there was a. My lord, kindly, if you lordship see the merit of the judgment, my lord, there is not, absolutely, my lord, the Easement Act has been provided where the wife and the son both file written statements separately, my lord. And they said that they are not the lessee, they have acquired the title by way of an oral heber. And in both the court, my lord, the concurrent findings of the court, they didn't able to prove the heber. So, my lord, when the true title has been.
Why you want? I just wanted to.
My lord, then I need to take instruction from my client that why you don't want, my lord. That I do not know. But the lordship, there was on the behest of the daughter-in-law, there was a 490-day complaint.
That is the daughter-in-law. I am again saying, sir.
Even the son deposed.
The daughter-in-law has departed.
Even the son.
Unfortunately.
Even the son deposed. That my lord, the grandson deposed against the grandson deposed against the my lord, that grandfather.
So.
My lord,
then you should introspect that why your grandson deposed against you. That's the thing you should introspect.
And now by this time he has grown up, the relationship has become strained. When they were child, my lord, in that time.
I'm just talking about
and I need to take
any chance of a mediation. I just wanted to send it for mediation. Looking at where is your client?
My client is here. May I take instruction?
Yes. He's a grandfather.
He's a father. He's a son of the plaintiff. Plaintiff is
the son.
No, that son. Against whose wife the suit was filed by the father-in-law. Father-in-law filed a suit against the daughter-in-law. He is the son.
His wife was there, or
his wife has expired.
His wife expired. So
only one son.
The suit is dismissed.
Suit was decreed. The appeal court, my lord, extended.
Dismissed.
Suit was decreed. Appeal court extended the protection under section 60B of the.
Suit is dismissed.
Suit is by the appeal court. By the appeal.
He is a defendant in the suit.
No. Only the suit was only filed against the daughter-in-law.
So who was substituted?
The son.
He is a son.
Grandson, my lord. Grandson.
How can a grandson be substituted?
Because my suit was filed by the father-in-law against the daughter-in-law. So the son and the daughter-in-law, the son's son has been substituted in place of the daughter-in-law of the father-in-law. His son has been substituted in place of his wife.
To fight against his own son.
But he is not fighting. The grandfather is fighting.
He's instructing you. and
No,
you
he's
say he's not
instructing me.
fighting.
He's instructing me so whether even reconciliation is possible or not here.
No, sir. What are you talking?
That the other sons are also there, my lord. He is saying that the other sons are also there. It is my lord, the interest of other sons are also involved. They are not agreeable to, my lord, sacrifice that property. That is also a ground, my lord. He cannot reconcile the issue with his
Says
son.
that they should sacrifice the property. Who says?
My lord, if that son remains there, my lord,
Your son is, I mean, not your son. Your father is alive.
yes, father is alive.
So at least he is your grandson. And your son is instructing him what to do, what not to do. That means
The father is instruct.
going against his own son.
That is true, man.
What are you talking about?
That is, but thing is,
He's going against his own. He may have a lot of disputes so far as his wife is concerned. Now she is not there. What is the dispute with his son?
a dispute went up to that stage. Man, I do not.
Whatever.
Man,
His son.
That's true. That's true. My lord,
What is the age of the grandson?
বয়স কত এখানে আছে বয়স কত ওনার ছেলের বয়স 30 years.
Must be doing some work.
কি করে কি করে কি working ration deal ration shop.
This is where you wanted to get him evicted.
No, it's a
From a
residential.
ration shop?
No, residential premises. Residential premises.
Why you want your son to go out? He's also married, I believe.
He's also married. The son is also married.
So
There was, my lord, he's enjoying the entire property, the alternative accommodation he has, my lord. Because the mother, my lord, she had the alternative accommodation where the son can reside easily, man. There is a 5-story building and she has 2 flats there. But that's true, my lord.
Responsibility of a father.
Sometime, my lord, the family.
What is the responsibility of a father?
Now he is 30 years old, my lord. Kindly consider.
The responsibility never ends.
Never ends.
Never ends. What is the responsibility of a father?
Well, that I do know. Well, that is not the issue. Well, I cannot tell that what the dispute went up.
This is what one has to look into for the purpose of mediation.
But you kindly send.
Have a notice on the other side.
So for the merit of the
Just give him a notice. Let him come. I'm not recording any order.
To the grandson, to the
Substituted respondent. That is a respondent. Give a
kindly
notice.
pass on one line order.
No order. Give a notice.
For the
Any urgent mentioning of honorable court number 1?
My lord, may I be permitted to mention, my lord, one matter, my lord. This is the, my lord, I want to take leave before your lordship to file this memo of appeal without certified copy, as well as the listing the matter tomorrow, because, my lord, there is a grave urgency in this matter, my lord. The order was passed on 25th of this month, my lord. I have already applied for certified copy, and my lord, this is a
What is the urgency?
urgency is that, my lord, the notice has been served upon me. My lord, I am a licensee of the railway authorities since 1976-77. My lord, my lord, that Amrit Bharat station, my lord, they have served the notice on Unauthorized Occupants Act during the license period. I have challenged that. My lord, after that, my lord, there is a stay before this honorable court. I filed one writ petition. My lord, on 25th, my lord, after the license has been, my lord, issued, they are not, though we are applied for renewal, they are not giving any renewal. But suddenly, my lord, since, my lord, the same has been, since, my lord, it has been since the
File it will appear on Monday before the regular.
yes, my lord, my lord. Also, my lord, the application maybe, my lord, both the leave will be granted.
What leave? For application, no leave. You go and file memorandum, application will be automatically.
Great.
Serve upon the other side.
Yes.
Learned advocate
Yes.
appeared.
My lord,
Monday,
may I be permitted to mention, my lord, item number 1 of the, my lord, the circuit bench matter before the Honorable Chief Justice, my lord. That matter, my lord, as per your lordship direction, my lord, I have paid the entire amount. My lord, kindly take it up at 2 p.m.
I appear for the respondents, my lord.
Who is appearing for the
I appear for the
My lord, friend is here, my lord.
2 p.m.?
2 p.m.
2
Very
p.m.
well, my lord.
My lord,
Much obliged.
my lord, may I permit to allow matter item number 11 from the daily list, supplementary daily list.
Item number 1,
Yes, what do you want?
My lord, as per the last order, this matter is very urgent as the issue is relating to state culture to the whole medical college in the West Bengal, my lord.
জলপাইগুড়ি ম্যাটার ওটা।
এটা তো জলপাইগুড়ি, এটা তো রেগুলার বেঞ্চ।
জলপাইগুড়ি ম্যাটারটা কত? এখান থেকে লিস্ট বার করে দেবে। জলপাইগুড়ি বার করে
ওই তো বের করে নিলাম।
পেয়েছো ওইটা না
একটাই তো ম্যাটার
ওইটাই
দুই চেকটা দিয়ে
নাম্বারটা ভেরিফাই করি ঠিক এইটা করি ওদের দিয়ে ভেরিফাই করি আমাদের এখানে হয়েছিল তো
এই ম্যাটার ছিল
ওটাই ছিল
Tomorrow.
My lord, kindly fix it
Give
to
notice upon the other side. Will appear tomorrow before the regular bench.
এটা করে দিচ্ছি।
My lord, lordship's persuasion ultimately paid off. My lord, the entire amount has been paid.
Lordship, we've received 1 crore 35 lakhs.
Lord, the-
Lordship, we have certain submissions, Lordship. Only, Lordship may consider that the legal expenses might be paid by the borrower. And, Lordship, any interest that the bank needs to pay to the auction purchaser.
First thing is that you demanded 1 crore 21 lakhs.
Lordship.
He has paid more.
1 crore 35.
So I think that will include everything into it.
Lordship, I think that also includes a bit of interest. The legal expenses is not included in that, Lordship.
How much?
Lordship, 75,000, Lordship.
Okay.
Well, only one indulgence, my lord.
Only thing is that you'll have to refund because he has not deposited as yet the rest of the amount.
No. He's supposed to deposit by tomorrow.
Tomorrow?
Yes.
So don't worry.
And Lordship, if any interest the bank needs to pay to the auction purchaser, that might be.
That is not required. Because
And-
we will set aside the sale.
And Lordship may protect our interest, the bank's interest against the action taken by the
We
auction.
are setting aside the sale, so what more?
Well, only one indulgence.
Lordship, what if the auction purchaser sues the bank, Lordship?
Because we have to find out the best price. Now he has given more than what he has
This
offered.
is the price, man.
He has offered 1 crore 10 lakhs. So second day, when he's offering more than that, the best price with the car back please.
We have received 25%, Lordship. Lordship.
Can you see what judgment of the Supreme Court is there?
My lord, that is this current judgment is the Bapna Motor Cellular, my lord. That is. I have handed over on the last occasion, my lord.
Where?
It is possibly lying with the file, my lord.
No, it is not.
There, it is
Oh,
not
yes.
there. Yes, that's a voluminous judgment, my lord. My lord, there, my lord, factually it is different. Why I
No, there was one judgment that question arose that after the sale was conducted,
Lordship.
whether the borrower, if he comes forward and say that there are a best price
Yes.
which can be given more than what has been done, the Supreme Court has said that the object of the sale is to get the
best price
possible price. When something is coming and paying more than what is there, there is no difficulty on the part of the court to interfere. So that is one judgment which I know of 2000.
Possibly, my lord, that is one
13
judgment.
or 13 or 14.
13. There, my lord, moreover, sale has not been confirmed also.
No, that is what I know. The sale has not been confirmed. There the question arose, once the sale is effected, the mortgage, then order 21, rule 51 and onwards, what would be the right of the borrower? All these things were considered.
After post amendment, my lord, the redemption right has been curtailed to that some extent, my lord. Because
Has been curtailed.
Can you call Mr. Mainak Bose? He appeared in one of the matter and my own judgment is there on that.
On that.
We might. We'll ask.
Call him.
Well, only one indulgence I would be seeking, my lord. They are also, my lord, the position is with them. My lord, kindly, my lord, ask them to.
The position has not been parted with to any third party.
Yes, my lord, that's with them. That's why, my lord.
Obviously, when the money has been received, they are concerned with the money.
They will remove the padlocks, my lord. That is the.
Absolutely, there is.
In course of today, my lord.
About, you should not have any apprehension. We know what is to be done.
Well, because the
we are all conscious.
Previously, my lord, the law was that if the money has not been, my lord, the full amount has not been secured, then, my lord, the borrower has a right of redemption, always. But that has changed after this judgment.
That law has
Now
changed.
it has become the only after issuance of the sale notice, if you don't pay, then your right will evaporate. My lord. That is the latest judgment. Once the publication is made, that means your redemption right is over. Okay.
This is, oh, no. Lordship, he's on his
He's on legs.
He's on legs before another court, Lordship.
Then this judgment is staring at your face.
Well, that judgment, my lord, in my respectful submission, my lord, there, my lord, the issue is completely different. But there, my lord, 9 attempts have been made, consecutive attempts, and the borrower, the purchaser has deposited the entire amount. Here, my lord, the case is factually different. Here, the sale is not confirmed.
Where is the SURFACE Act? Do you have a SURFACE Act?
Because, my lord, after all, my lord, this judgment, my lord, factually.
Lordship, it's a bit marked. Turn it on. Okay.
Subsequent to the rule 91, to the solutions, so to what to the Calcutta redemption point. Then to the point. This place, what's the offer of the rest lines? Secret activity consider.
দেখি এখন বলা মুশকিল তো this judgment was also rendered before the honorable single judge. His lordship has also taken it into consideration. Thereafter, my lord, given me time to
Because
oh,
Bafna
that was
judgment
only-
completely goes against him.
Here it says the after publication.
No, but my lord, they are the factually, my lord, the judgment has to be applied, my lord, in the factual context. With due respect to this judgment, my lord, here the facts are different. Because, my lord, their sale has been confirmed.
Ratio of this judgment is
Ratio says, well, here I have challenged the veracity of the sale notice also. There, my lord, sale has been confirmed. Not once, my lord, 9 consecutive occasion. Here, my lord, the first sale notice. Secondly, my lord, here the purchaser has not deposited the entire consideration amount. So therefore, my lord, 25% has only been deposited. And by any means, my lord, it will not cause any loss to the bank also.
Lordship, this is also a second and subsequent sale, Lordship.
Is to obtain a price. I have got the reserve price. We have the reserve price. I have got and the reserve price. Equity is also good. Equity is also good. He may, with the consent of borrower and secured lender, consent of the borrower is there. Secured creditor is there. Make the sale at such a price. The price of the being the higher than the reserve price, don't also be the future interest. Reserve price consent has not been obtained. Sitting right and say that the price. Somebody save the potential, save the same save the same for the further options. For the option, or you can have price. Party
Yeah, market prices below the so that's it. Just you cannot. Right.
What was the price which was offered by the intending purchaser?
Reserve price to it's a reserve price.
1 crore 10 lakhs, Lordship.
Reserve price was
What is the reserve price?
1 crore 10 lakhs.
1 crore 10 lakhs. $21. The $121 is
Trial court relied this judgment.
Ultimately, equal lordships.
Oh, I'm talking
Yes,
about
yes.
the trial court relied this judgment.
The Bafna Motors.
Not entirety, my lord.
Yes, Lordship.
No, you said whether relied or not.
No.
It was not cited.
Yes, it was cited.
Then
Yes,
Trial
it
court
has
says
been
only
relied.
for the purpose of my lord,
was
whether
cited,
I can
Lordship.
challenge the sale or not. That's why the trial court said that the appropriate forum would be DRT. That, but so far, my lord, that otherwise, my lord, the trial court would not have granted me time to pay the amount. If, my lord, in strict sense, this judgment has been relied, then 1 day's time would not been given. That means, my lord, the honorable single judge was very much conscious of this judgment.
Lordship, page 2 of the judgment, Lordship. It clearly states that the law as it is stands is well settled in the judgment of Bafna Motors, Lordship.
Well, that is not
It
for,
has
for
been
the
relied.
purpose of, my lord, that redemption part. That is only for the purpose of, my lord, whether, my lord, the sale notice can be challenged before the High Court, or, my lord, it has to be challenged before the appropriate forum. Not for that purpose. Otherwise, my lord, I would not be given that liberty, my lord.
Lordship, the judgment clearly says that
My
the
lord, I am unable to understand
petition-
what prejudice bank will suffer.
Please do not argue when you do not have a proper working on the brief on a proposition of law. They have noticed
Lordship.
clause 2.
Lordship.
We have noticed very clearly unamended and an amended provision. We have
Lordship.
also noticed the amended provision in 2016 it is brought.
Lordship.
And this is all obviously a case after 2016.
Lordship.
But one thing which we notice has not probably not been taken care of by the Supreme Court in that judgment. You have the copy of the surpassing.
Lordship, my copy is with your Lordship.
When steps are taken under section 13 of the surpassing, then the procedure for sale is to be done according to security interest enforcement rules.
Lordship.
The procedures are there, and it says that when we will have to publish the notice, how many, the period of time which you will indicate in the notice and all.
Lordship.
There is one provision there
Lordship.
which has not been complied by you. Look at this provision. 8 and the last proviso provided further. As they provided further, it is given.
Lordship.
Read it,
Lordship.
what it says. What it
Lordship,
says.
Rule 8.
Rule 8, proviso, there are many provisos.
Lordship.
The proviso beginning with provided further, last one, or a preceding one. Same page, left hand side.
Provided further. Lordship, that Rule 9.
Provided further.
That if the authorized officer fails to obtain a price higher than the reserve price, he may, with the consent of the borrower and secured creditor, effect the sale at such price.
He has not worked. He has not gone into this.
Lordship.
Now, if this proviso is to be applied, then you did not get a price more than a reserve price. You get the price that is of a reserve price. The word is higher than the reserve price. If you do not get it, higher than a reserve price. If you did not get a higher, then the consent of a borrower and the secured creditor both are required.
But Lordship, it's written he may and not he shall.
May and shall are interchangeable under the tools of the interpretation. Are you aware?
Lordship.
Sometimes the may be read as a shall.
Lordship.
And sometimes the shall may be read as a may, depending upon the purpose.
Lordship.
Purpose is very clear. When it is used in a proviso,
Lordship.
then something is to be done. So if you have not, that means the sale which you have accepted is also wrong. Not there. You have to take consent. We are just thinking that if we go in this line, this was not considered in that judgment. This Rule 8. Then we can easily say that this sale was not in conformity with the provision. So you will get exonerated, he will get the relief, the matter would be put to an end. You are not liable to pay any interest, because you also want that it should go back. You have received the best price.
We have received, Lordship.
Did not notice this provision, nor used.
I should have. Well, I thought that it would have to be
I
challenged
thought
before the TRT, my lord.
So easy.
That's why.
As a counsel, you have to look at all the possible points.
I 30 days notice, my lord, I have looked.
Only you come, I am a bona fide borrower, I want to repay. This
I
is
should
what
have,
the
my lord.
article said, well. But you will give some handle. The law is there. Law is putting a debtor. How to wriggle out of the law. That's the role of a lawyer. You have to assist the court.
That is there, my lord. I should have. না বুঝেছি আমি রুল 8 প্রভাইসো লাস্ট প্রভাইসো
Madam, what we are thinking,
Lordship.
that if the sale goes, then section 13(8), this judgment will not come. Because there is no publication of the notice, because it is gone, offending this provision. Then the only course open is that you can publish to invite a price more than a reserve price.
More than the reserve price.
So it will be deemed that there is no publication of the sale notice or a sale. So 13(8) will not come. Then his right to redeem remain, according to this judgment also.
Lordship.
What is playing in our mind?
Lordship.
Then his right remain, redeem.
Lordship.
Okay, now he has paid, redeem. So you can come out of it. The genes of our lawyers are still embedded in me.
I should have, my lord, checked up on this one, I must say. Maybe. আমরা তো ভাবিনি এখানে একটা চ্যালেঞ্জিং
Because you also want that the property should remain. You have got the best price.
We have got the price, Lordship.
So you do not want anything because.
And
you
we do not
bidding
want the
less,
auction
now you have
purchaser
got
to
more.
come and sue us, Lordship, at the same time.
That is what is there. So you are also a human being. His property should remain with him. You got all the full money. He also want his property to be protected. So this is what we wanted to just find out. The way and means. Please suppose as the
Okay, I'll try again.
that's the only handle I could have. They had to it.
But that is the only handle, my lord. The other thing also,
Otherwise, you
30 days
say
notice.
facts are different. Facts are different. Very difficult to wriggle out of the ratio.
But the ratio says because once publication is there, my lord,
That's the section itself. After amendment, before amendment, it was not.
It was not, my lord. That's why I'm saying, my lord.
This is why the Supreme Court has said that unamended provision gives a unbridled right to the borrower to redeem at any point of time before the confirmation of the same. But here it says from the day of the publication, the moment they made a publication, your right to redemption goes.
Lordship.
But my lord,
but your right to participate does not.
Yes, in the auction.
But you did not.
Well, that is also, but my lord, my right to challenge this sale is all along remains, my lord.
Again, we are not entering into right to challenge in what forum.
If the sale notice
Have to
suffers
give
from
That's why
infirmity
I
or
say,
discrepancy.
more you open your mouth, more you will put yourself in trouble. More you open your mouth, more you will put yourself in trouble.
Very, my lord, I would say, my lord, it's a very deep trouble. All this trouble has started, my lord, after this judgment.
Straight away যেতে পারি সুবিধা বলছি
Come to them.
এটা বলেন উনি কি জাজমেন্ট রেফার করতেন সেটাই তো বুঝতে পারছি পার্টিকুলার অ্যাক্টিভিটি Lordship, Mr. Bose is arguing a matter in court number 41.
Just thinking if you can lay hand to that judgment of the Supreme Court. I just want that.
Lordship.
Just so your lordship,
If I
what
have not brought that judgment, the difficulty is so there is one judge.
it's your lordship that judgment.
No, there is a Supreme Court.
Supreme Court 2014, my lord.
14 or 15, I remember. That was the judgment goes in the line that the purpose of the conducting the public auction is to extract the best price.
Lordship.
If it appears that the price is absurdly low or the price is such and somebody comes and pays and offers to pay the higher price, even he did not participate in an auction, he will be permitted to do it. That is what the purpose was. Just wanted to get that judgment, which just pass over, let him come, let us see that what can be done.
Lordship. Lordship.
We're waiting, my lord. May I also, my lord, find it out whether I can procure that judgment also, my lord?
Please find out if you can lay hand. And on that particular proviso of Rule 8 of the security enforcement, what is that interest rule? What? Enforcement interest rules or what?
Security interest rule. Lordship.
Interest.
তাই হবে।
Lordship, Rule 9. Rule 9.
Rule 8 provides.
Rule 8, 9 and 9.
That is the last proviso,
Last
provided
proviso.
further.
Lordship.
Nine sub-rule. Rule 9.
Rule 9.
Rule 9, sorry. Rule 9.
Lordship.
To bring him. There is no difficulty. We are sitting tomorrow also in the first.
First of your lordship.
Then your Lordship may keep the matter
No
to.
difficulty. We can keep it this matter on 10:30
Then Lordship, tomorrow. Lordship.
and consider this
Lordship. Lordship.
and find
I
out
will
if any
also have a talk with
judgment
Mr. Bose.
If handle, both of you have agreed, but the
That's why, my
sanction
lord.
of the court you require, he says that we should be protected at least from the hands of the bidder. He's agreeable, but give something.
But the purchaser has also not deposited the entire amount, 25%.
Again, I say, the date has not expired. He is supposed to pay the whole of the amount by 29.
20.
If he pays by 29, can you say that he is out of time? No. Realize, and this judgment is steering.
That this yes, ma'am. This judgment is steering. This is the only judgment, ma'am.
Please realize that. কালকেই আছে first.
কাল সকাল।
না না এই তো জমা করে ফেলেছে ও দিতে পারে but 10:30 will not be because the bank
Item number 73. Lordship. I am appearing on behalf of the defendant, respondent, appellant lordship, judgment of reversal. Suit dismissed. Appeal.
The nature of the
Suit for declaration as a easementary right. Suit for declaration as a usury right. Easement.
easementary right. That's an easementary right.
Yes.
Right? Easementary right of by prescription or by necessity?
By necessity.
Necessity.
Trial court specifically hold, as well as appellate court specifically hold, as per the documents, reveals the alternative passage is there. Even if appeal court degree the suit.
And then,
Appeal court degree the suit. Suit was
so see, there was a commission head.
commissioner report is there.
Yes, what the commissioner says,
Commissioner says, as per the LR record of right,
not as per the law, he cannot. He will go and take a physical verification.
lordship kindly come to the
He will say that what is,
appellate court judgment.
yes, then take your seat.
Loss.
Sometime.
Yes.
why trial court rejected the, dismissed the claim?
Because of the presence of the alternative passage
What was found by the trial court?
from the document,
Where is the finding?
page 4 and 5. Loss, page 7 and 8.
Suppose there is something, if I remember, there was one matter which you argued and cited one judgment of the Supreme Court that on the auction sale and the right of the
Borrower.
to redeem
My lord.
by offering a higher price
My lord.
or by another means we can bring the good borrower who can pay more price what has
My
been
lord.
offered by the Supreme Court has said that so far as the concept of the public auction is concerned, it's to get the best of the best price. If somebody
Balji
comes
Khimji.
forward,
Balji Khimji. Balji Khimji was the original judgment. But the problem is, my lord, in the under the Surface Act, the 2023 amendment.
I have seen. Now, please consider two things because that judgment, recent judgment of the Supreme Court is cited.
Bafna Motors.
Bafna. Bafna Roman 2, the last conclusion is problematic. It says that after the amendment happened brought in 2016,
Yes.
the moment the public note, the advertisement or the public notice is given for auction, then right of
Redemption go.
extinguishes.
My lord.
But you see, there is no corresponding amendment having brought in a security interest enforcement rules. If you look at Rule 9.
Well, that has been brought in 2023. The Rule 9 amendment.
Further, it says further provided. That is the last provision.
Very good.
Further provided. What?
No, I don't have the rule.
There are many proviso in Rule 9.
Right.
You say the proviso which starts with provided further.
Last one, I believe. তোমার কাছে আছে ওটা প্রোভাইসো লাস্ট
That's the book. The first is that rules. Have you got the rules?
No, me. No, I don't have it.
Came and argues the matter without any book in his hand. It says, I'm telling you, it says that the provided further.
My lord.
Suppose.
Yes, my lord.
It says that in the event the authorized officer did not get a higher price than a reserve price.
My lord.
Then he may, by the consent of the borrower and the secured creditor, sell the property
at a lower price.
At the reserve price.
Reserve or lower or reserve.
It does not get higher price than the reserve price. The word is this. It does not talk about lower.
Okay. Okay.
It says if it does not get a higher price than the reserve price.
All right.
The case, in this case is that reserve price was offered. Amount accepted.
Okay.
Not full. So that is an obligation under that provision. And if it is not, then the consent of the borrower and the secured creditor was not obtained by the authorized officer. So the sale at the reserve price should not have been taken into consideration.
Correct. Without the consent of the borrower.
What may is used, but may is interchangeable.
Man.
Can we go to that extent and dilute the, I think, Bafna's case, because it did not take into consideration that what would happen when only the reserve price is offered?
So, well, then your lordship will be considering a sale which is contrary to the rules, procedural irregularity in sale. So the Bafna doesn't in any way come to the aid of the bank.
So that is what I say. No, now this is a very unique case. Bank has also agreed. They have they have paid the higher amount than the reserve price.
Okay.
It is 30 lakh rupees more they have paid a borrower. Only thing is that we have to then
set aside the sale notice.
So that is what we wanted, so that 13(8) will not come into play because the moment the sale goes,
Correct.
so there is no publication. The publication also goes.
Absolutely.
They have to make a further
Republish.
publication.
So further publication means right of redemption once again resurfaces.
They are under
Right.
Bhavana.
Correct.
That redemption right remains.
Yes.
So they have now redeemed it. So find out if you can.
I'll give you a lordship.
Tomorrow actually.
I'll give my learned friend the judgment. Because tomorrow, my lord, I'm traveling. Tomorrow I'm out of station. So if I
Can give it tomorrow
I-
and today itself,
well, I'll try and give it today.
and also find out what can be done in this.
My lord, my lord, my lord.
The bank is also agreeable because it has received more amount.
Naturally.
What he will receive from that, from the purchaser. And he has paid more amount. So naturally, so we were thinking in that line. Object of the sale and then
Maximization of the value of assets. But that principle, maximization of value of asset, that principle applies to the insolvency and bankruptcy code. But to what extent will that apply to a surfacey sale?
it was the case of a surface at that point. IBC did not see the light. You cited that Supreme Court judgment of 2014 or 15, I believe.
My lord. But my lord, this, after the 16th amendment, those judgments.
That is what is the right of redemption goes.
Hmm.
But right to get the highest price, that principle will still remain.
Hmm.
These are the principles attached to the public auction.
Correct. Your lordship was referring to the last proviso.
Yes, provided further.
Well, that if the authorized officer fails to obtain a price higher than the reserve price, he may, with the consent of the borrower and the secured creditor, effect the sale at such price.
So here what has happened, reserve price was given and the price is offered is the reserve price. Not even 1 paisa more.
So would sale at the reserve price require the borrower's consent or not?
If it is required, then that
Sale is
not
bad.
be- can't. But sell it.
I will give my learned friend.
Think about that.
My lord. Then your lordship keeps it on Monday or.
The problem is it
Oh, I
has to
see.
be disposed of tomorrow morning.
Oh, I see. Very well. I'll give it to your lordship. Very great.
Thank you.
তুমি আমার নাম্বারটা নিয়ে দাও রাত্রিরে ফোন
Lordship, trial court judgment, page 7, issue number 4.
Been right by necessity to go check. If there is no alternative pathway, then it is a easement of necessity. That cannot remain landlocked. I can't reach through my land by air. If there is no only pathway, may runs over the property. Then is right by necessity or arise for what his case is. He has said that here. Not clear. Your own evidence is against you. What you have said, everything you have said in the evidence. So vividly, you narrated the topography of the land. That creates a problem.
Lordship.
And that is what the appellate court has recorded the whole evidence.
Yes, Lordship. Lordship, can trial court specifically hold that. Lordship, there are
Court wrongly held that the plaintiff has not been able to produce any document of proof. Right of easement, how the documents are to be proved.
But document,
Admittedly, this is your property, is not claiming any
document,
right of ownership over your
Lordship, document says the alternative passage is there.
property. Because you vividly say everything in your evidence, and the entire quotation is there.
Lordship, very well, Lordship knows that in the
You
village
also
area.
said that this 5 feet passage is used by me and also the plaintiff. You have said, defendant.
Yes, then Lordship.
DW1. What to do?
In the cross-examination, Lordship, kindly see.
Sir, we have to go by that. Once there is an admission, what cross-examination have
No,
to explain?
That
Just said
that
said
passage.
witness further deposed that it is a fact that the western side of a plot number 134, which belongs to you.
Lordship, next.
He has, it is at page 4, middle. He has his house at the western side. The said witness further deposed that it is a fact that at the western side of plot 134, there is a plot number 135, which the plaintiff claim, which is a plot of the plaintiff having his residential house. And it is a fact that the plaintiff travels through the said southern side of plot number 135 to reach the plot number 134. This witness further deposed that the passage of the southern side of 134 is 1 feet 9 inches, while the passageway travels through plot number 135, 33 or 34 is 4 and 5, and is used by myself and also the plaintiff, and the said passage is also used by the author. So that is what is an admission.
Lordship,
This is DW1. You are a defendant.
Yes,
sir.
yes, Lordship, I am the defendant. Lordship, difficulty is that in the village area, everything is open. Everybody can went every portion, and that
Your admission is sir,
that
you can't
passage.
say that I am using it. Plaintiff is also using it. This passage. Thereafter, what remains?
That in the regarding easementary right, Lordship, here there must be seen that whether any alternative passage is there or not.
Sir, I am.
If the document proof.
Tell me the law, sir. Let me learn the law. If the party himself admitted that this is a passage which is used by him for his access to the property, by me for the access to the property, and by many hawkers there, then does it require any other thing to be gone into? Easementary right is a right to use. Admittedly, right to use means that the property does not belong to a person who has a right to use.
Yes, Lordship, right
So
to use.
he is admitting that he does not have any title in plot number 133, 134. He is saying that I am the owner of plot number 135. But to go to plot number 135, I am using this is the only passage which I am using.
Lordship knows very well, Lordship. But actually, this passage was used by the defendant. That is the Uttan.
Your admission, sir.
Yes, yes, I seen that.
So,
That portion I seen
God.
that. But in the regarding easementary right, alternative passage already proved that alternative passage is there.
No, it is not because the trial court says that he has failed to prove that there is no alternative passage. That is what the trial court has said. Trial court did not decide that there is an alternative passage.
Yes, yes, Lordship, kindly come to page 8, 8, Lordship.
Please 8. Show us where is that? He says upon the consent of the defendant. And the plaintiffs do have a right to use path through plot number 133, which is not there. More so, there is a path on the northern side of 136 and 135.
Lordship, page number 7. Now from the LRROR, which is submitted by the defendant and marked as exhibit B and C, and the RSROR and LR plot information submitted by the plaintiff and marked exhibit 1 and 2, 1, 3 respectively. Page 7, Lordship. I find that it has been clearly mentioned that there is a pathway for dark number 135 and 136.
Through dark number 133 and
35 and 36 through dark number 133. And in Bengali it is written 35 and 36 দাগের যাতায়াতের রাস্তা আছে. More so, it has been mentioned that the dark number 137 is elaborated in the northern side of plot number 135 and 136 is the pathway. That is the alternative passage. Dispute regarding plot number 134. Plenty only claiming over the plot number 134. I have a essential.
DW1, then thereafter DW1, your evidence. You have opted to read.
No,
Read the last paragraph.
Yes, that part some lashes.
You have stopped up to this.
Loss that
Read that last paragraph.
loss I DW one losses some dispute
Some
losses
mistake, some
most very
something.
good. DW1 in the cross examination it has admitted that the plot number 133 and plot number 134 are being used by the plaintiff and defendant. And it was, yes, loss I cannot I cannot improve the what is the thing. But must be my
ওই পর্যন্ত গিয়ে থেমে গেল তারপর ওটা পড়লো না
my on
কাল করতে বললো যে কোথাও নেই কিছু
Let 74, may I please, my lord? Let the defendant is appellant. Defendant is an appellant in this second appeal, my lord. The plaint was rejected on the basis of an application filed by the defendant on Order 7, Rule 11. That was set aside by the appellate court below. Challenging that, I came before your lordship, my lord. Your lordship, the suit was filed for eviction. In the plaint case was that I am a the property is a Thika tenanted property. Property is a Thika property. And the plaintiff who have instituted the suit is a Thika tenant and I am a Bhadatia. I am a Bhadatia. That suit, after receiving the notice, we preferred an application under Order 7, Rule 11. That was
Thika controller, not the civil suit.
Civil suit. The trial court held that Thika control.
8.3 or 5.
My lord.
Which one?
Section 21 and 5 and
8.3.
8.3. 8.3. The trial court have held that yes, Thika controller or to alert. The appellate court reversed the judgment on the basis of on the appellate court.
Where is the judgment of Justice Jyotirmoy Bhattacharya?
Yes, my lord, I have it. 2016, 2016, volume 3. Page 1, my lord.
Where is the West Bengal Thika Tenancy
My lord.
and Regulation Act?
এই দুটো দিন এই দুটো দিন ওই দুটো ওটা দিয়ে এই দুটো দিন একই বই আছে
ছোটদা
এক
Eviction. Any dispute any case of an eviction
Where is the judgment of Justice Jyotirmoy
Yes,
Bhattacharya?
Reference. It's not tenancy of all, like the tenancy. The tenancy will be covered by this. Actually, the reference is not tenancy also made up. After this, you can make for the the structure will be the vendors and the secretary to be ultimate. Don't say that. Definition of it shall be heard on the substantial question on whether a suit for eviction of a Bharatiya at the behest of the Tibetan is maintainable before the civil court by reason of section A, reason of the provisions contained in West Bengal Tenancy Act 1997. आगे नहीं बोलिएगा now by reason of section 8 within bracket 1 of the West Bengal Tenancy within bracket acquisition and regulation bracket close Act 2001. Next, whether a suit for eviction of a Bharatiya by the Tika tenant is required to be filed before the Tika control, irrespective of the fact that the said tenancy is governed by the West Bengal Tenancy Act 1997. Third, whether the provisions, whether the
The forum provided in an act which has
date fixed by correction করে দিই ফাইলটা দিলে একটু ওই কারেকশন করে দিই
যাচ্ছি যাচ্ছি
75 হবে না?
Before the civil court. Before that, then the
Before my lord goes to the record, my lord, I want to make one submission before your lordship. There is an application for granting leave to prefer the instant appeal because the appeal is intended to be filed by the person who are not the party to that proceedings. I mean, 144 order is appellable and whether second appeal, first appeal lies. সেটা তো এখানে বিচার হবে।
কিছু লিখেছে ওখানে
144 is not appellable.
It is appellable and affirmed by this honorable court. In this matter, my lord, I'll satisfy your lordship.
No, one thing is troubling me because the second appeal you have filed.
Yes.
Application seeking leave and condonation.
whether here or the single bench.
That is the what, my lord, whether
But
the single bench
leave-
has
No, my respectful submission, leave, my lord, is a part of the appeal. That probably, my lord, your lordship would hear. Because section 5, there is no dispute.
No, that is not disputable.
You have been given here order 41 means an admission of an appeal.
So till the leave is,
Appeal, the leave is granted to.
there is
file
no
an
appeal.
There is no appeal.
There is no appeal.
So it has to be first passed through the muster of the single bench. And the moment the single bench grants a leave, then it will be an appeal.
Best of luck.
And then section 5, and then come back. Then we will consider now it's a regular appeal.
Yes.
We
Yes,
have to
yes.
see whether.
So section 5, I have no quarrel over the proposition, but whether the
Because the substantial question of law will not be decided. It is only whether your right is there to file an appeal.
No,
and then agree to
bow
proceed.
down.
if your lordship, my lord, can you consider in another way? If today the leave is granted to these parties, whether the limitation will start from the date of passing of the
So
deed?
then the question would be section 5, will it constitute a sufficient cause
Yes.
or not? No doubt, there is no difficulty. If you were not aware of the order and when.
That will be a ground under section 5.
Whether the date of granting leave will be the date for
No.
No.
একটা জাজমেন্ট আছে কিন্তু আমি জানি কিন্তু খুঁজে পাচ্ছি না। হ্যাঁ আছে।
I tell you, then there are many things. I do not know what will happen. Previously, when the appeal is memorandum is filed without the application for condonation, even the rule has not been amended. The proper way is to return to the advertised record and let him present before the division bench along with an application, which is still there.
And if
But
it's
after
not
the
filed,
introduction of the central filing section, then what has happened is immediately on presentation or what filing, it becomes registered.
so that your lordship also remembers, if the section 5 is not filed along with the melody
Memo.
appeal, they will also have to show cause as to why it was not filed along with the appeal.
It was that if the.
That delay also needed to be
After
explained.
taking back, if there is further delay in presenting.
Yes.
That period.
To give that period.
That period also.
Not that period. Anyhow, what we are thinking in that line, because there was a judgment which came in case of a contempt. Section 20 of the Contempt of Courts Act says the 1 year from the date of the.
Cause of action for
No, the violation.
cause of action for violation.
Now, it says that on a day when it is the contempt has to be moved, is the first motion, the contempt has to be done, and thereafter the court will consider. The question was that there was a application for contempt filed, but it was not moved within 1 year. It was moved after a gap of 2 years. A plea of limitation was taken. That what would be the meaning of the word first motion? Whether the limitation would come or not. So the court upheld, yes, it should be, but because of the introduction of the central filing section, so one has to adjust it in that way, and then the limitation will not run. Similarly, when appeal is to be filed, leave to appeal is only for the purpose of regularizing the filing of an appeal or a right to file an appeal. Does not mean unless that right is declared, the appeal would not be treated as the valid one. But it will relate back. It will
Yes.
relate back to the date when you presented it.
No, Mr. Mukherjee argued this point, my lord, in that metro cash and carry matter. If your lordship remembers, my lord, before Justice either Justice Bhaskar Bhattacharjee or Justice Jyotirmoy Bhattacharjee, where he argued this about the leave to appeal and whether the leave to appeal, if it relates back to the date of filing of the appeal or not.
I do not know at that point of time, was it a central filing?
No, it wasn't.
No.
Wasn't.
That
There is a judgment of there is adjudication by Justice Bhaskar Bhattacharjee as his lordship. His lordship of the opinion, this section 5, you have to file because irrespective of fact when you obtain the leave. But when you obtain the leave, it automatically that this will be an explanation for the purpose of the
It will be
delay.
an explanation, but section 5 you have to file.
No, my argument was
I'm telling you, your right to appeal is there.
Yes.
Suppose if you come to know of the order,
Much later.
found that it affects your right, yet you sat over for a period, will you not explain?
No, my lord.
There is a delay.
Yes.
for the date of the knowledge for the date of
If
filing.
they come and file an objection and say that, yes, you had a knowledge. Like ICICI Bank and Galudia.
Irrespective of fact, Violent can consider it on merit.
Violent remembers.
It appears that an application seeking leave to appeal and an application
Yes, my lords. I appear for the appellant. My lord, before I move my application, my lord, the list shows there is some defect.
No, not
My lord,
just
what I have
defect,
been
it's
made to
infractions.
understand, my lord, the defect possibly, my lord, the defect what has been raised by the department, my lord, is possibly, my lord, they say that there is mismatch of the cost title. Which, my lord, subject to correction, my lord, I tried looking into the
The name of the parties could not be verified in the absence of a full cost title of the title suit. So,
my lord, full
have
cost
you any-
title. Yes, my lord, that lordship will find.
Says I am unable to say.
But my lord, it is there.
No, I
The
say, my lord,
plain-
this
plain
appeal is
start-
infractions. Appeal is infractions.
My lord, my learned friend will permit me to move my application.
No,
but
I'm
it's a-
taking a preliminary point.
my lord, drastic order has been passed, my lord. A deed of partition of 2008, my lord.
Why you say instruction?
Ad interim order.
Which order is under check?
My lord will kindly
What is the date of the order?
date of order
Lordship
12th of
hasn't, my lord-
September 2024. Memo of appeal 20
My lord hasn't
12th of
finished
September
2024.
my lord,
And it was operative.
7th November,
which has been extended, my lord.
and that has been
My lord,
extended.
I filed, my lord, my lord, I had filed my appeal, my lord,
Your
prior.
lordship, my lord, sits in that full bench.
There is a divergent of views. I am a part of that larger bench.
Well,
And the point of reference is whether it is obligatory on the part of the litigant to file an independent appeal against every extension of the ad interim order. There were two conflicting judgments of the division bench. For that, the three-judge bench is there, me with Justice Pampa Sarkar and with Justice.
Shobhashachi Bhattacharya.
There are conflicting views. Take out, come immediately.
my lord, I'll come back.
Immediately tomorrow, come out.
I will file, ma'am.
It will cure, that will destroy his.
I shall file another.
Tomorrow or day after tomorrow, Monday.
My lord, maybe on Tuesday, my lord, I will take.
Tuesday. We are not recording any order, let him come with that.
My lord will kindly grant me one liberty, my lord, to file an appeal with the website copy of the order. Lordship will kindly grant me that
Copy of the trial court.
trial court order because I admit it.
That you have to see,
My lord,
provided you applied for certificate copy there.
I will do that. My lord, as regards the defect is concerned, my lord, if lordship kindly directs it.
There's no difficulty, come.
Tuesday, ma'am. Deeply obliged. Deeply obliged.
না তো দেখা যাচ্ছে না
Sir, there's one caveator I've served.
অন্যরা
Others, I will.
Give it to.
I will.
Don't make that voluminous copy, make it a thinner one.
No, I will simply be filing memo of appeal, my lord.
অনলাইন আছে
Application.
Can't do that.
Memo you are not supposed to serve. Don't serve.
nowadays my lord
Whether they
everybody
apply
serves.
to- No, it's not required. It will be a part of the paper book, then they will get it.
My lord, your lordships these days don't even wait for the paper book, so your lordships hear out the appeal, so might as well serve and finish it off.
Let this matter be listed on Tuesday. For the next.
Item number 79.
My
lord, item 79, my lord, I am followed for the petition. I'm led by Mr. Chaudhary, my lord.
Point. Same তো বলে দিলেই তো হলো
Oh, yes, which Chaudhary?
Mr. Shobhashachi Chaudhary, my lord. I'm led by Mr. Shobhashachi Chaudhary, my lord. I thought, my lord, he wasn't there. My lord, that was the information I received, my lord. That's why I started.
এটা অ্যাপিল করতে হবে ইনজাংশনটা এক্সটেন্ড হয়ে গেছে
same point same
I've told to do, sir. I told him in confidential. Don't take it otherwise. I'm taking this point.
এই ওই বেঞ্চটা বলো ওটা আমি ডিসাইড করে দিই একবার
After,
সরকার ইজ হিয়ার অর
no, she didn't know. Jalpaiguri. I have to make
no we wanted to
after the vacation. Just after the vacation.
Mr. Chaudhary, the difficulty is there is a divergent of opinion on that. And the matter has been referred to a lot.
I see.
Decided over by me, Justice Sompa Solkar and Justice Chinuno. So at one day we really heard the matter substantially. And I think Mr. Shaktinath Mukherjee was also requested to appear as a amicus curiae to assist the court to this extent. The difficulty is because the point of reference is whether an independent appeal is required to be filed against every extension of the adultery order or interim order passed. Or once the appeal is again challenging the parent order, then there is no necessity of filing the independent appeal on mere mechanism
Extensions.
We are in the process of deciding that. So for the time being, what we are saying that you please come and file it so that
Very well, my lord. We'll
no problem.
Then all I can beseech your lordship, my lord, that larger bench, my lord, may decide the law one way or the other.
Okay, you are also invited to address, no difficulty. We will be happy to have the views.
Very well, my lord.
We have invited, we have requested every member of the bar to come and assist us on this because we wanted to put a quitus to the thing because there has been somebody says no, not required, is a mere extension. Somebody says no, it's an independent, has an independent application to find. Mr. Mukherjee is very diplomatic.
He's made a very diplomatic, it cannot
He's a
happen.
very diplomatic. So he took a third case. He says if it is a mechanical extension, not required. If something more, some observations are made while extending, then it constitutes an independent order, so appeal is to be filed.
There has to be a definite.
Because it is a mere extension that an application for extension is filed. The defendant prays for extension of time to file opposition. Time to file opposition is allowed. Let the opposition be filed. The order is extended for further. This is application of mine. So it's a mere extension. So according to him, no further appeal lies.
But happens, Milord, if I argue on the returnable date and the court doesn't agree with me but says that the interim order will
Court
continue.
records some findings, then according to him, it constitutes an independent order, so you have to challenge. That is what is.
The lordship is keeping these matters after 2 weeks or 3 weeks or whenever.
Again, the further extension would come. Mr. Chaudhary, kindly visualize. Now it has been extended, which must be for a limited period. If you come immediately, no difficulty. We can look into the parent.
Very well.
I tell you, I have some judgments which I feel must be taken into consideration. Or this point is first is Provas Doloi's case. Provas Doloi's case.
My lord was
Supreme Court has interpreted the distinction between a renewal and extension.
Extension of lease.
Renewal and extension of a lease.
Mr. Ashok Sen had argued.
So there the distinction has to be seen. Then the bench of our High Court in Suprati Ghosh.
Renewal extension.
Yeah, but there are
argument করেছে সেটা
So take care of that. What can be done? Immediately file it tomorrow or day after tomorrow or Monday.
Very well.
So we are adjourning it for what?
Forever? 10 days, right? 10 days? Or 7 days, lordship?
Whatever, that's your.
1 week, lordship will adjourn it.
1 week. Let the matter be adjourned for a week. We enable the appellant to take an appropriate step. Is another question that comes. That suppose
The difficulty is
if there is a mere mechanical extension, if an appeal is filed against the last extension, will it cure or it is required to be filed against all extensions?
because I understand the matter has been fixed on second or third, and suppose we file an appeal in the meantime on second and third, before it is another order will be passed.
That is what I'm saying.
7 দিন লাগবে, 7 দিন।
But then that even may I pray for 2 weeks? We'll just see what happens. 2 weeks.
2 appeals.
Whatever, my lord, we'll take our chance.
2 weeks.
Great. Order record করবে না? Adjournment.
তুমি সিনিয়র গুলো তোমার জিএসটি দিতে হবে।
No, we have recorded the order. Don't worry.
80
দিতে হবে।
same. Well,
Same.
yes, same, my lord, same.
No, he's not appearing.
আমাদের
He's appearing in 83.
80.
79 and
Oh, you are appearing in 80 also.
Now he is appearing.
তোমাকে দেয় ছি,
Now he is
চল,
appearing.
তুমি ছেড়ে দাও।
Same order.
order.
Question.
81.
Okay.
এটা খোলো। খোলো, ওটা 81 দেখে। তো মনে হচ্ছে এটা।
I am appearing, my lord. This appeal arising out of, this is the original certified copy, my lord.
Service.
I have start, my lord.
Give the certified copy also. Hey, these are started by us. Hey. Where is section 5?
Can one, my lord.
Let the certified copy of the impugned order filed to Yes.
82.
I'm for the appellate matter. Suit for eviction on the ground that, my lord, the defendant is a trespasser. Suit.
That is not eviction, recovery opposition.
Yes, I'm sorry. Yes.
Yes.
Yes. Now, my lord,
He appeared, lot of questions were put, now he has put you, taken you. Not that matter. Okay.
This coming back, coming up to the.
Okay. Now, suit for recovery, there was another matter. So, lot of queries were put, then he took time and went. I just thought that he has brought you now.
That is another matter that is scheduled to be discussed.
Now, suit for recovery of possession. Suit for recovery of
As a
possession on
trespasser.
the ground that, my lord, the defendant is a trespasser. Suit, my lord, decreed, taking into consideration one document, my lord.
You are a plaintiff or a defendant?
I'm the plaintiff.
You are the plaintiff.
Now, suit decreed, taking into consideration a document which was, my lord, tendered without any objection.
What document?
My lord, a deed of assignment to, my lord, on the basis of which the defendant or the predecessor of the defendant, my lord, had earlier surrendered possession. I'll give you a lordship very briefly, my lord.
Assignment by you, sir.
He was carrying on a business, he assigned the business and left, took money and left. That is the evidence. Thereafter, my lord, the assigner, the heirs of the assigner, my lord, had trespassed into the property. Now, suit decreed. The first appellate court, my lord, disbelieves that document, which was tendered in evidence without any objection. And my lord, proceeds on the basis of an application or two applications for, my lord, under Order 41, Rule 27. Though, my lord, the documents referred to were never brought on record.
I don't. I could not mean. I could not understand.
The defendant filed.
They must have disclosed order for in the documents under Order 41, Rule 27.
Only the application.
What additional evidence they will give?
He has said that I shall rely on rent receipt, I shall rely on electricity.
They have not disclosed rent receipt through firisty or something. Sometimes in the
Firisty, I understand, yes. No. And my lord, it has been sent back on open remand. It could have been decided there only. Firstly, my lord, the application could not, no order in my
even Order 41, Rule 27 allowed.
Yes. Consider everything. Ends of justice, consider everything. Open remand, decide everything.
What is that rent receipt which they have not produced the rent receipt?
I really do not know.
Really? Okay. Where is that? Yours? How can it be?
Well, kindly, they made two applications. Kindly come to page 58 first of this stay petition. Page 58.
Is it true that you did not produce any document?
No, but I.
As an by
Document has been mentioned in
you
the.
must have mentioned in the petition.
Did
you produce the document? I am asking.
In the petition, the
I am
document has
asking
been mentioned.
a document where the existence, physical possession of the document was given.
But that time to take instruction because in the petition.
You may have said that I want to rely these
documents are mentioned.
Those documents were not either annexed nor produced before
that
the
I have to
appellate
take
court.
instruction. That to in that effect I do not have any instruction. I have to take specific instruction.
You take instruction.
I will come.
I tell you very frankly, if it is a correct position that it was not, then it's a wrong on the part of the appellate court in allowing Order 41, Rule 27 application. Because the language is such. If you come forward and if you agree, then we can set aside the order and direct the appellate court to rehear the matter. You produce those documents before the appellate court.
My lord, may I come back with the proper instruction?
In fact, yes. In fact, my lord, as I said, they made two applications. First application even did not have any schedule.
But that application was not placed.
No. Page 58, kindly come to, that is the first application.
No, what we can do is that if that being the position, we will have to say, and then if they really want, they have a document, let them produce before the first appellate court and let the first appellate court decide afresh on that score.
But may I come back with the
And then,
instruction?
if they have produced, then we will consider whether.
Absolutely.
But may I come back, my lord, because
averment on oath is that it was not produced.
If it is produced, my lord, there must be a certified copy of the firisti. I can got it.
Yeah, it is not. Then we will remand.
Yes, my lord.
Otherwise, if you say insist, then we will admit it.
But I have to take instruction on that but I don't have any knowledge on that. So whether there's a document has been annexed or not.
Someone might-
But because if I take a certified copy of the felicity, it will be.
Let this matter be
I-
decided on Monday.
I, my lord, told the client, I disbelieved. When they came to get the application settled, I disbelieved. I said, nothing doing. They must have filed in by way of fieracy. Came back with the instruction that no, there is nothing on record.
What is the application filed by you? Can one?
Sorry, Mal. Yes. Can one. Page 58 is the first step.
Can one?
Yes, ma'am.
But stay of operation of the impugned judgment and not to
Never had a privilege of the
deal with the property.
such an application.
QHA.
Say that they came for a settling the petition. You settled the petition.
কি গন্ডগোলটা করেছি তো জানি না বুঝতে পারছি
Heading নেই
No,
sir.
one or whatever.
Oh.
Can one heading নেই application for what?
Never had that opportunity.
No,
to settle.
I'm sorry, my lord. It's my fault. I was not, my lord. I really, my lord, went into the body. I did not. It's my lacuna.
No, you are privileged.
I should have been more careful.
You are privileged that you have been given an opportunity to settle. Never.
Application for stay এগুলো তো লেখা নেই না।
The stay or the injunction used to be drafted and filed by the advocate on record of his own, never came for settlement, to settle it. Cases. Monday, come. If it is true,
No, my lord, I come back for instruction.
the court, without looking at it, whether there is any nexus, there is anything on the air, it will decide. The document may not have any nexus to the cause. Will it not look into prima facie that yes, those documents are necessary, and then will consider whether the provisions of Order 41, Rule 27, those grounds are satisfied. First thing is whether those documents are at all having any nexus or necessary. On the basis of abandonment, I will rely on a rent receipt issued for another premises. And the court will believe that yes, you go and produce rent receipt.
Then may I come back?
Monday. As for orders,
Gotcha.
it may be first or two second matter
Okay.
in the morning.
Monthly stocks with it.
I normally reach in time.
Reaching?
Reach in time. Normally.
Sir,
On
monthly
time.
list.
In time. In
Or-
time
Or
or
on time.
On time.
Oriental 7-8.
Sir, monthly, maybe a monthly list. Well, can you take it out 2 years because
No, that is means much before and just at the nick of the time. That is the difference.
monthly.
Yes, what you say? You want an adjournment?
Yes, I don't know.
Not tomorrow. Not this week. করে দাও,
Item 7.
But Monday will be the monthly list day. If you also take it at Tuesday.
Shakespeare says that if the rose is known by another name, will it lose its fragrance? It would remains the same. So unnecessarily
For orders
monthly
to
or
fully থাকবে আর কি, yes.
for orders means at the top.
Lordship.
Matter would be there.
Judge Saib direct. He will be on that.